So first we're going to talk about how alcohol beverage labels are regulated. And again, this is taking into perspective the federal regulation. States may vary or have additional requirements, but generally speaking, United States federal government, by way of TTB, reviews and approves or rejects every single wine, beer, spirit label that's sold before a product enters interstate commerce. And the exceptions to that are, of course, as we mentioned before, the wine under that 7% threshold or the beer that does not meet malt beverage definition. Those are under FDA jurisdiction, so it's a little bit different. But this section talks about the standard wine, beer, spirits. So this means basically that label applications required to be submitted and approved by a TTB before a product can go to market. So to some extent, before that wine bottle is on the table at your dinner party, the government has had a significant amount of say in terms of what you can and cannot say on a product's label. Process isn't always straightforward, even though it's spelled out in the regulations, 27 CFR Part 4 for wine, Part 5 for spirits, Part 7 for malt beverages. It's not always straightforward. There's a lot of subjectivity. Labels, of course, it always depends on what a client or a product wants to say on the label. Some things cause red flags or may cause hesitation on behalf of the government, particularly if it's kind of taboo or never before seen. So it's not always clear cut, and it can entail a lot of back and forth communication on behalf of the applicant as well as on behalf of TTB. That's really where we as attorneys kind of step in. We advocate for our clients, we argue, things like that. So sometimes when you submit a label application to TTB, it might come back needing corrections, and it varies. It could be TTB saying something's misleading or not appropriate, and that's where we can kind of come in and argue for a client that wants to keep something on a label that doesn't really want to remove something. So just to give you a general idea in terms of how many label applications the federal government receives per year, it's certainly well over 100,000. It's increased a lot in the last few years. Last year, 153,867 labels. And the federal government, TTB's ALFD, Advertising, Labeling, Formulation Division, has really tried to curtail this to some extent by publishing something called allowable revisions to approved labels, which effectively says you can change certain things on a label if you have a certificate of label approval, a COLA, that's been issued by TTB in hand, provided that other things don't change in the labels. So for wine, for example, you're permitted to change things like a vintage year on a label. You can change the alcohol content on certain wine, beer, spirits, provided it doesn't really change the classification of that product. And that's going to really depend on the specific product that it is. Because things like that can alter the tax classifications. That's really the concern there. And other things, a lot of times clients want to add additional text on a label. Maybe it's non-mandatory information. And in that circumstance, I always advise my clients on the more conservative side to always submit a new label approval, even if you're just changing things slightly. It does depend, but for the most part, if you're adding additional text, making new claims on the label, you're going to have to send it to the government for approval. So what is TTB's goal when it's regulating all of these labels? So basically, the Federal Alcohol Administration Act gives TTB the authority to approve, reject, send back all these labels. And its goal really in doing this is to protect consumers, to make sure that consumers have adequate information, that information on labels, information on products that are sold at market are not misleading or deceptive to consumers. So it's basically to provide consumers with adequate information or to prevent deception. But when you submit a label approval to TTB, a label application to TTB, and it comes back with the needs correction saying this label is misleading or this label is deceptive to consumers, it's not really always clear what that means. Something that's misleading to TTB may not be misleading to you or your client. So it does present a lot of problems because things are very ambiguous. And it can often also depend on who is looking at these applications. So sometimes you get a specialist who may be more conservative that may not agree with you, and other times another specialist may approve things. There are also certainly circumstances where the same specialist previously approved something and won't approve the same exact thing even though one or two minor details may have changed on the label. It happens. It's just kind of the extent when you're dealing with a government. So again, basics, prior approvals required, certificate of label approval, we call them COLAs in the industry. Most of the requirements, 27 CFR Part 4 for wine, 5 for spirits, 7 for malt beverages. The average processing time is about 20 to 30 days for a label. It depends on the commodity. It does vary. It kind of just depends as to what their threshold is, what their what's in line, what's in the queue. And it's reviewed for accuracy, truthfulness, to prevent consumer confusion or deception. And if you have a product that has a formula approval, a lot of times, or all the time, it is reviewed against that formula approval. So if you have a distilled spirit specialty product or a wine specialty product, the formulation specialist that reviewed that formula often recommends a classification, a statement of composition that must appear on the label. You have some leeway, but generally it needs to be within that relative format, and the labeling specialist can take that to heart. And again, it's a matter, some specialists are more conservative than others. Some of them will rely on those statements to heart and don't allow much flexibility. And again, it's a lot about our job being an advocate. So who needs a COLA and who's responsible for obtaining these COLAs? On imported beer, wine, and distilled spirits, so this means imported products that are coming from outside the United States. So for example, let's say you're importing a wine from France. In that sort of relationship or situation, the importer of record is responsible for applying to TTB for a COLA before the product reaches the United States. Generally, it really should be before the product is shipped, but that doesn't always happen. And they need the COLA, customs needs the COLA in order to clear the shipment at customs. Otherwise, you need a COLA waiver, which is only available in certain circumstances. So generally in those circumstances, the importer applies to TTB either through COLAs Online, which is the online portal, or through paper application. They use their own permit, and they submit the labels that have been provided by the supplier, the winery, or the distillery, or the brewery outside the United States. They'll submit those labels to the government for approval, and they're the individual. They're the company that's responsible for getting that approval. For wineries and distilleries, if you're bottling the products yourselves on site, then you would be responsible for obtaining the label approval. Again, it's before bottling, before selling in interstate commerce. If it's an alternating proprietorship, we talked a little bit more about that. That's effectively where the tenant winery or the tenant brewery would be responsible for obtaining the COLA themselves. If it's like a custom crush or a contract brewing relationship, then the actual facility, the brewery, the winery that's producing those products would be responsible for obtaining the COLA, as opposed to the client that is going to eventually own the product if they're buying it from the facility that's making it. Breweries only if selling in interstate commerce. John, I don't know if you want to jump into that or expand anymore.
Yeah. For breweries, if you are just selling your products at your tasting room or within the state, you don't need a federal label approval. However, there are a number of states, I think at least 6, 7, 8 states, probably more, that require a federal label approval regardless of whether the product is sold intrastate or interstate commerce. Minnesota is one, Illinois is another, I believe Florida may be one too, where even though a brewery may not need a federal label approval, the state requires it.
And then there are some exceptions known as the COLA exemption, where if you're only selling within the state, you can apply to TTB for an exemption from a COLA. And right now there's a lot of commotion about that, particularly from the wine perspective, where a lot of different individuals in the industry are concerned about the exemption because people may be claiming American viticultural areas or vintage years that may not match what is actually defined by the CFR or what is allowed by the CFR. And it's technically legal because it's an exemption from TTBs corresponding sections of the CFR. So there's a proposed rule right now in the Federal Register that has some changes to the COLA exemption that have been proposed from the wine perspective. And you can certainly take a look in the Federal Register if you're interested in that. And if you can't find it, feel free to shoot us an email. We can point you to the right direction. The other aspect is if you are importing beer, wine, or spirits for trade sales, for sampling, you can apply to TTB for a COLA waiver. And this needs to be done before the product comes to the United States because it has to be approved by TTB. They'll stamp it, and it usually takes about 10-ish or so days to get that.